Welcome to this presentation. This will be our second presentation on Chapter 10, which is the chapter that covers the discovery process. So let's begin. The topic for this presentation is going to be what the documents look like that relate to written discovery, both the requests and the responses, including the objections that you'd make. So let's begin. So we're going to look at the requests first. I guess that kind of makes sense to talk about what one would be asking, and then we'll see how one might respond to those requests. So let's first of all consider the term written discovery. We talked about 5 different discovery tools when we were talking about the various the discovery tools. We talked about interrogatories, requests for production, requests for admission. Those are the 3 written discovery tools we have. Then we have 2 discovery tools that aren't written. They are depositions and medical or physical examinations. There is technically a 6th type of discovery. People usually don't talk about it because it is a special type of deposition. It's called deposition by written questions. When people ordinarily use the term deposition, they mean when there are oral questions that are answered in real time by the deponent. But it is possible to do a deposition via written questions, and in that situation, the deposition doesn't happen in real time. What happens is that the person answers the question, the questions are submitted by the person who is noticing the deposition, and then the deponent answers those questions, typically at some later time. Therefore, it's not a give and take. There isn't an opportunity for the person who asked the initial questions to ask follow-up questions. As a result, it's relatively rarely used. Typically, it's used when the person who is being deposed is not a party, and therefore you can't ask them interrogatories. But you don't want to spend the money to actually have a deposition by oral questions, because that's going to be quite a bit more expensive to arrange and to accomplish. Also, it usually means that the person who is being deposed is kind of a disinterested party. He doesn't have an agenda, so he's not going to be cagey or secretive about his answers, that you expect that he's going to just kind of be forthcoming and candid. And so the fact that you don't have the opportunity to ask him follow-up questions isn't probably going to be a big deal, because what he has to say, he's going to say. Anyway, that is what a deposition by written questions is. And that is a type of discovery, and it is a type of written discovery. But I wanted to make it clear to you that that's a pretty atypical type of deposition, and most of the time when people talk about depositions, they wouldn't be talking about written deposition. So this one kind of, I guess you could say, is a little bit of a special case. So let's talk about the things that these written discovery tools all have in common in terms of structure, and we'll see that they are very similar. You will see that there's going to be a caption to the lawsuit. It'll be the same caption that you used on the pleadings and which you'd use on any motion. Then you'll have the title of the request. That's going to occur in the same spot that we've seen other titles, for example, the original answer or something along those lines. We'll see a new section though here, actually from here on. This section will be some new stuff that we haven't seen before. And then we'll have a signature block, which will look essentially like all of the other signature blocks we've looked at. And we'll need to have a certificate of service. That will be just the same type of certificate of service that is used with a motion or when you file the answer. Obviously, again, we don't use a certificate of service when we're filing our complaint, because that has to be served. So let's look at the guts here, the 4 things, I guess 5 things that we have in the middle. And we'll go through examples of each one of them. But one is the to paragraph. That's the paragraph in which we explain who we're sending this to, who are we asking these questions of. And then we have a preamble. Basically, that's introducing the reader to typically the authority for that rule. You might say, well, gosh, if you're sending it to another attorney, why do you have to tell him or her about the basis of the authority? Surely that's known. And you're right, it is known. It's just a custom to do. If you were to omit it, it would still be a valid request, but it honestly doesn't, take very long, and so it's commonly done. Then we get kind of to the meat of it, and this is where we actually start seeing the real purpose or the real goal of the document. You're going to start with instructions for responding. You're going to want your instructions to direct the completer to answer to provide as much information as possible. Obviously, you want more rather than less. So your instructions to him or her are going to be very, very broad. Of course, you don't want the answers to be vague. You want them to be detailed, but you want them to cover a very broad category of topics. And then you're going to have definitions, and you want a similar thing here. You want broad definitions. So, for example, when you talk about documents, you'll define the term documents not just to be pieces of paper, but also to be data and files and things along those lines. And then you're going to have, once you've defined the terms, and you're going to use those terms, and you're going to expect the person completing the questions to follow those instructions as they answer your specific request. So these two feed into the specific requests. So let's go and actually look at an example here. Here's our caption. We've seen a lot of these already. There's no big surprise in this. This is a pretty typical caption for something filed in federal court in Texas. And here we have our title. We can see the 3 zones that we've seen before. This is being filed by the defendant. If we flip back here, we can see there's only one defendant, so we don't have to differentiate. And then we can see the number that this is. This is the very first one, and then we see the actual name of the document. And again, there's only one plaintiff we can see here, so there's no need to specify. If there were more than one plaintiff, we might be sending different interrogatories to each one of the plaintiffs. So we have this 3 elements to the names that we've seen in other documents as well. This is the to line, and we can see we're sending it to the plaintiff. I mean, that makes sense because that's who it's going to. But because Mr. Justice is represented by an attorney, we don't send it directly to Mr. Justice. Now, he's the one who's going to have to answer them, but it has to go to the attorney because he's represented. It would be a major ethical breach for us to send interrogatories directly to a represented person. And you can see that we have listed here the address. This is not Mr. Justice's address. This is the address of his attorney. And now we have the preamble section. Defendant Bert D. Bandage serves these interrogatories on Plaintiff Buford T. Justice as authorized by Federal Rule of Civil Procedure 33. Plaintiff must serve an answer to each interrogatory separately and fully in writing and under oath within 30 days after service. Is any of that new information to Mr. Justice's attorney? Of course not. It's just a pro forma thing that people stick in there. Okay, let's look at, here's some information about the instructions. I kind of already have talked a little bit about this. The instructions, again, are telling the party, Mr. Justice in this case, and essentially his attorney, hey, how to go about answering the questions. And it's going to provide categories of details when a particular term is used. This isn't the definition section, but this is the instruction section. So you're going to give him some ideas about how you want him to approach these questions. It's very common because, again, you, the questioner, want as much information as possible to veer towards being overly broad and unduly burdensome. And so it's pretty common for the responder to make objections. It's also usual for the instructions to be single-spaced. You could double-space them. There's probably not any rule that prohibits it from being double-spaced, but it's pretty common for them to be single-spaced. Okay, and here's some examples of interrogatories. When asked to identify a document, please state the name of the document, the name, title, and address of the person who prepared it, the name, address, and job title to whom it was addressed. There shouldn't be a space here, apologize. Or circulated, or who saw it. The name, address, and job title of the person the person now in possession of the document, and a description of subject matter of the document. You can see having these instructions mean that, let's say you have 30 questions, you don't have to say this for each one of the 30 questions. Let's say each one of your 30 questions are about identifying documents. Well, you can say it once, and then this instruction would apply to each one of those 30 interrogatories. And again, you can see how detailed it is. You're really trying to mine the knowledge of the answerer for everything that he or she knows about this particular topic. And then again, we have the definition section. This is, again, your terms that you're going to use throughout the document. Why set it up so you have to continuously be providing information or explaining what you want? Why not just say it once, and then the answerer can refer back to that one explanation every time he or she has that question. You want to define the term precisely. Not overly broad, not underly broad. You want to consider exactly what you want to have drafted. If it is vague or ambiguous, the responding party may object to the definition or may answer questions based upon his interpretation that is advantageous for him. And again, just like the instructions, typically the definitions are going to be single-spaced. Here's some examples of definitions. The following definitions shall have the following meanings unless the context requires otherwise. You can see they're going to be in quotes, so when you define a term, put it in quotes. So we have plaintiff, you, and your, or any combination or portion thereof, shall each mean referred to and include plaintiff Buford T. Justice and his agents, representatives, and all other persons or entities acting in concert with him or under his control, whether directly or indirectly, including any attorney or legal assistant, agent, employee, representative, or principal. So you can see with this that this is a definition that has been probably carefully crafted over many years. You aren't going to write this again and again and again. You're not going to rewrite it. This is canned boilerplate stuff that you will be cutting and pasting from another example. To come up with all these ins and outs in this language would be a pretty time-consuming process. Obviously you're going to have to cut and paste the name of this particular plaintiff and this particular defendant. You're going to want to read it to make sure it makes sense. For example, let's say that the last time you had used this, the plaintiff was a woman, where you're going to say her here. Or if it were a company, it might say it's here. So you have to go through and search those terms. There might be other things you have to tweak. So when you cut and paste, you still have to be a very careful reader and proofreader to make sure you've made all the appropriate adjustments. But you, on the other hand, don't need to reinvent the wheel. You don't have to think, well, gee whiz, we want the attorney, but who else should we say here? Oh, legal assistant maybe, but what else? Well, look, we already have it written. We already know what to include here. And here's another example. The accident shall mean and refer to the automobile accident involving plaintiff and defendant occurring on this date on West Houston Street in Sherman, Texas. Okay. And so we actually don't have the actual interrogatories here, but obviously at this point we would go to the actual interrogatories and list those questions. Let's go to the subscription. It looks just like you've seen so many subscriptions before. This one, again, there's different formatting you can do with it. This is a little bit fancy formatting. The important thing is, though, you have all these pieces. You have the name of the firm, you have the attorney's name, you have her bar number, you've got the street address, the telephone number, the email address, and the email address and the fax number. And again, typically you're going to have also who you're representing at this point. Okay, so let's go to the certificate of service. And again, nothing unusual here. We need to have the date. We need to have the person that it was sent to his address, and the mode of delivery, and then the name of the attorney who is certifying it. So this is a handy certificate of service. This is a very common one that you'll see in Texas. Sometimes people will indent this. You certainly don't have to, though. There's no legal reason that you'd have to. And it's also common to have the name typed underneath here. So we are done with the request formatting. As you can see, it has several different parts. If you have any questions about those parts, please be sure to bring those up in class. Now we're going to talk to the response that the other side might make, the person who's received these requests. Not only what the responses might look like, but also what the objections might be to those particular requests. So here we have, again, the caption. You can see there's nothing different about this caption than what we've seen on the other captions, including the request for interrogatories we just saw. So looking at the caption, you won't be able to tell whether this is something completed by Mr. Justice's attorney or Mr. Bandit's attorney, or perhaps by the judge. And you can see we have these same pieces that we had before. We have the title, but we've changed the title, right? So now we have, this is the name of the original document right here. So we have the three parts, you know, defendants, first, set of interrogatories. But now we see that this is, we have, again, plaintiffs. We have objections and answers too. So this is the longer title. And you can have titles that will go on for easily 3 or 4 lines. So this is not an especially long title. You can see they've shortened the original name of the document a little bit. I think it said defendant's first set of interrogatories to plaintiff. That's okay. You don't want to cut it too much. And if there were more than one plaintiff, you'd want to keep to plaintiff Sally Smith or whatever. And you can see that we're writing this back because it's from the plaintiff to the defendant. So now we have, hey, we're sending it to the defendant, but we're not sending it directly to the defendant. We're sending it to the defendant's attorney. And again, this is the address of the attorney, not the defendant's address. And we have that little preamble, and you can see it's not very creative. It's just plaintiff Buford T. Justice serves these objections and interrogatories to defendant Bert D. Bandits for a set of interrogatories in accordance with Federal Rule of Civil Procedure 33. So again, that's just setting us up. This is what we're going to be doing in this document. And you can see there can be objections to the instructions. You can see here, plaintiff objects to instruction 2, plaintiff, you or your, because it exceeds the responding party's burden under the Federal Rules of Civil Procedure. This would be very common to make these types of objections. You shouldn't make frivolous objections, but it's very common to, in a way, you're preserving your options under the case. You're protecting your interests. You probably aren't going to end up in front of a judge with this particular objection. It's a pretty common one to do. Overly broad and unduly burdensome. This is another one. We're objecting to the definition because it's overly broad. And again, it's more common to say probably overly broad and unduly burdensome, but this is also fine. And now, so we've done objections to the instructions, and we've done objections to the definitions. And again, there may be a lot more into these categories, there probably will be. Now we have objections and answers to interrogatories. And you're usually going to have the objections as part of, you know, so you make an objection to each interrogatory. And typically people start with the objections and then you move to the content. So usually you'll make all of your objections, you'll say, notwithstanding the foregoing objections, you know, plaintiff or defendant, whomever it is, answers, notwithstanding and without waiving these objections, plaintiff, you know, answers in this way or whatever. And you can see what the question is. Identify each person answering these interrogatories, supplying information or assisting in any way in the preparation of the answers to these interrogatories. So you can see this is the first interrogatory that we have. You know, before we were talking, going back here, that we didn't actually see any interrogatories. Well, this is the first interrogatory right here. So And you can see our answer. This one we didn't make any objections to. This is, by the way, a very common question, and there's really no basis for an objection here, so you go ahead and answer it. So Buford T. Justice, you put the name of the client, obviously. Now you may be thinking to yourself, well, gee whiz, he's an idiot. He's not really answering any of these questions. It's me, the paralegal, and or the attorney who is the one crafting the answers. Well, of course that's true. That's not a big secret. Everybody gets that. But at the end of the day, Buford T. Justice is the person who's going to sign it, and he's going to be doing under the pains and penalties of perjury. So yes, the document has been quote unquote lawyered up, but Buford T. Justice is the one who's uh, uh, swearing that it is accurate. And so you can see here we have Buford T. Justice, and we have the name of his attorney. And these are the people who answered these questions, supplied information, or assisted in any way. It's pretty common for there to be more names listed here. Particularly if this weren't an individual, but say a corporation who was being sued, we obviously can't really list the corporation as having any ability to answer questions. So you'd be talking about a human being here, and obviously you'd still have an attorney, but you very possibly would have multiple human beings because there's probably going to be questions about different aspects of that corporation. So this list can be very short or very long. And again, we have the signature block. It's the same. Obviously, it's going to have a different attorney here because we're on the other side now, but it's going to be a similar structure. We're going to have the name of the law firm. We're going to have the name of the attorney. We're going to have the bar number. We're going to have the street address of the law firm. We're going to have an email address, a telephone number, a fax number. And we'll also have a listing of who this person is representing in the matter. And we have a certificate of service. We have those same parts. We have the date of the mailing. We have the person who's receiving it, including her mailing or her mail address. We have the method that it's being sent, and we have the signature and the name of the attorney who is sending it. Obviously, this is not going to be the same person that this is. These are attorneys from either side. So if this is the defendant's attorney, then this is going to be the plaintiff's attorney. This is who he's sending it to for a response. So this name here is going to match this name here. And that's the same with the interrogatories. Going back, let's just see, so hopefully this will make it clear. The person that Carrie, who's representing the plaintiff, is sending it to the defendant's attorney. So Carrie is sending it to Senior V Partner. That's who she's mailing it to, and let's see. Oops, here we go. Well, yeah, sure enough, that's exactly who she's mailing it to at that same address. This is a document that we haven't seen before. It's a verification. Verifications in some state courts are not that unusual, but they're not that common in federal court, except when you're dealing with a request for production and interrogatories. And what a verification is a sworn statement. It needs to be notarized. This is one of the reasons why law firms usually have a legal secretary or receptionist or a paralegal or multiple people, more likely, who are notary publics who can function as a notary. Anyway, let's just go through the parts that we see here. So the first thing is this is basically an affidavit. We're calling it a verification. It is required for answers to interrogatories, and it's not the attorney who signs it, the paralegal. It is the party. It is the client. If it's a corporation, it's going to be somebody that has been selected to have this particular role. Obviously, it's a human being under those circumstances. So let's look at some parts. It's pretty common to have this on the verification. Some people will put the verification on the caption, so you'll start with the caption up on top, and then you'll have, many times you'll still have this identification of where the verification is happening. But you don't have to have the caption, so it's a option here. And this is typically going to be called the verification. You might call it the verification of Plaintiff Buford T. Justice with respect to you know, first set of interrogatories to plaintiff or something like that. You can have a longer name or not. So we have here, this is going to reference the notary, so that is our notary. So let's imagine this is Nancy Ophelia Terry. That is this person's title. Before me, the undersigned notary, so this person right here, on this day, and we have the day right here. And again, the notary might well have a space here where the date can be written in. Personally appeared Buford T. Justice. Okay, so this isn't by telephone, this isn't by Skype. This person, Buford T. Justice, is in the same room physically as the notary. He's the affiant, so he's the person who is being sworn in and who is undertaking the pains and penalties of perjury in completing this document. A person, so Buford T. Justice is a person whose identity is known to me. This doesn't mean that Nancy Ophelia Terry knew Buford T. Justice before this verification happened. I mean, they may well have known each other, but it may be that Buford T. Justice has shown Nancy Ophelia Terry his driver's license or his passport or some other identification. After I administered an oath, you know, just as you would typically in a courtroom, do you swear to tell the truth, the whole truth, you know, et cetera, that way. Affiant testified as follows. My name is Buford T. Justice. I have read the foregoing answers to defendant's first set of interrogatories. The facts stated in them are within my personal knowledge and are true or correct. Now, many times notaries do not actually make the affiant say these words, but have him read it and then he signs it. And then after he signs it, although certainly the notary could require that he say the words. After the notary signed, or excuse me, the affiant signs it, then the notary is going to sign it as well and is going to put his or her stamp. Oftentimes the notary will also have a log, and she or he may want Buford T. Justice to sign that log, and so there will be two signatures that he will have, and then also write out his name and perhaps provide, say, his driver's license number, his passport number, whatever is being used to confirm the identity of the person. So that is what a verification might look like. And again, you're going to want to have these on any set of interrogatories that you are submitting. If you don't have this and you submit them, then you haven't completed the process, because this is an essential part of the documents. Before we end this, I'm just going to go and pull up Rule 33. So we're going to go to Federal Rules of Civil Procedure. Since we were looking at this particular one, and this is the rule about interrogatories. You're not required to keep this information in your head, but I just wanted to show you what the rule is. Hopefully you'll get into the habit, whenever we talk about a particular rule, of flipping to the rule and reading it. One of the skills that we try to emphasize in this program is getting familiar with looking at primary sources of law, things like statutes, cases, regulations, and also rules like this. The Federal Rules of Civil Procedure are among the easiest primary sources of law to use and to become familiar with. And so if you're looking to get familiar with that process, this can be a good launching point for that. Okay, so let's look at these rules here. Here we go. So let's look at some generals. The numbers. No more than 25 written interrogatories, including all discrete subparts. So you can't have 25 numbers, but each number has 10 subparts. Now, each one of the parts is going to count as its own number. Keep in mind, there are those automatic interrogatories that are asked, and those don't count against the 25. Again, there may be the ability to have more under certain circumstances. And the scope is, well, you know, anything that is covered by Rule 26B. In other words, it has to be relevant, but it doesn't have to be admissible. All those things that we talked about in the earlier lecture. Let's look at how they're going to be answered. Okay, they have to be answered by the person to whom they are directed, so he's the one who needs to sign it. He has to sign it based upon his personal knowledge. And again, but the person might be a corporation or some non-human person. And in those situations, it has to be any officer or agent. And again, someone has to be selected, and you want to try to select somebody who has the most information and who's reasonably available. How long do you have to answer? Well, you have within 30 days after being served. And each question has to be answered, and it has to be answered under oath. And any objections have to be stated with specificity. If you don't make an objection, you're waiving it. And you have to sign the answers, and the attorney has to sign any objections. So the client, the party, is responsible for the answers ultimately, even though very likely the attorney and or the paralegal are the ones who actually wrote them based upon the information from the client. But of course the attorney is the one who's responsible for the objections. Let's see if there's anything else of significance. Let me go ahead and clear that. Okay. If the answer to an interrogatory may be determined by examining business records, and if the burden of deriving or ascertaining the information will be substantial for either party, the responding party may answer by specifying the records that must be reviewed in sufficient detail to enable the interrogating party to locate and identify them as readily as the responding party could, and giving the interrogating party a reasonable opportunity to examine and audit the records and make copies of those. So let's say that there's a question asked. A is asking B some questions. And B would have to do a lot of research through a lot of documents to put it all together. Well, B can instead say, hey, A, here's the info. You find the answer. And in many cases, that will be permitted. Now, in my experience, usually B doesn't want to do that. B wants to go ahead and answer the question. But there can be some cases where that might make sense. And so it can happen either way, but more commonly you do take a stab at making the answer. So if you have any questions, please feel free to bring them to class or come to my office hours and we can discuss them there. This concludes this presentation, the second presentation relating to Chapter 10 of Discovery. Thank you for your attention and have a wonderful day.